Hello students, can you quickly respond if I am like audible, visible properly? Let's just take a minute and then we'll start with this live session. This is going to be a very interesting live session because we'll be first discussing few aspects of law here, then we'll be dealing with one passage, and then we'll be dealing with some wonderful questions, right? So stay tuned just a minute so that more people join, because we have created a new link and we are expecting people to join. So once they join in, we'll start with this session, right? So be live, be live. Right. So meanwhile, by the time other students join, let's have an interactive session. Let's discuss a little bit about this law, right? Can you tell me what is this law about? This law has replaced which older law, which was otherwise there till this point, till 1st of July 2024? What was the law which has been replaced by this law? Yeah, use the live chat. IPC, CRPC, right? It is not IPC, it's CRPC, right? Okay. So three criminal laws. When we talk about criminal laws, essentially there are three criminal laws which are treated as the backbone, right? They are the essential criminal laws, right? In that regard, if we talk, those three criminal laws are the Indian Penal Code, the Criminal Procedure Code, then we have the Evidence Act, which is applicable to both civil as well as criminal processes. But these are the three laws which have been changed by the government through this present amendment, right? So this particular amendment was brought very earlier, right? That means this year, early this year, we saw this particular amendment, but this was made applicable from 1st of July 2024, right? So this is one new aspect that you could learn. If a bill is presented and if it is passed, if it becomes an act, that doesn't mean that it is straight away being made applicable. You have to see whether the government has notified it to be applicable or not. For example, this present law, although it was passed, it was only after the election that the government notified saying that this is applicable. Similarly, if you go to the IBC, right, the bankruptcy code, insolvency and bankruptcy code, there are certain chapters of that act which are still not applicable. So unless and until the government notifies and says that all of these provisions are applicable, till that point they are not applicable to the people of this country. Right? Now that on 1st of July it has been notified, from 1st of July this laws will be applicable. Right? Okay. So criminal procedure code, right? That's the answer. Now I want you guys to answer this particular question that I'm going to ask you. Can you tell me, obviously if it's criminal procedure code, it obviously discusses about the procedure related to criminal trial, whether it be trial, investigation, the entire criminal process, right? Now, if I talk about various functionaries, right? If there is a procedure, that means the procedure has been imposed on few people that you have to follow this procedure. Can you tell me who has to uphold these procedures? Who are made to follow these procedures? What are the machineries? What are the entities which have to follow these procedures? Think about different machineries, different stakeholders who are responsible in delivering justice. Who are they? If I say that there has been a criminal offense, right, and the state has to see to it that the accused is punished, what are different functionaries who come into picture, who have to make sure that the justice is delivered? Is it just court? Are they just judges? Police, right? So someone has answered police. So police is one effective, one very important functionary, right? Who else is there? Ombudsman? No. Right. Who else is there? Now, right. So let me discuss this first. Right. So this is the law that we are learning today. Right. So if I talk about the functionaries, the basic functionaries under this law, there are 4 functionaries. First is the executive magistrate. Then we have the judges. Then we have the police authorities. And then we have the jail authorities. These are the 4 functionaries under this particular act. As you know that executive magistrates or someone who is holding the position of executive magistrate, they're supposed to prevent the crimes. So most of the functions related to executive magistrate, most of these people are IAS officers, right? These executive magistrate, their work is what? To prevent crime, right? For example, the magistrate, executive magistrate has power to impose what? Curfew. If he feels that there can be extreme situation, riots or anything, he can impose curfew. Similarly, he can ask someone who is notorious, the state is expecting that he would do crimes. In that case, what would happen? The executive magistrate can ask a surety from him, right? Or preventive detention laws may also, there is huge role of these executive magistrate. The first functionary is executive magistrate. Then we have the judicial officers. Obviously, the judicial officers are supposed to conduct a fair trial with following the proper procedure, and at the end either convict or acquit the accused based on the evidence with proper reasoning to be given by the court. Now, the third functionary, obviously that comes before judges, that is police. The police has to do proper investigation and it has to file the charge sheet. What is that? The police has to do the investigation, and based on the evidence collected, the police have to move to the court and tell to the court that we believe that based on the evidence we have collected, these are the charges for which the accused should be punished. Now, during the trial, the prosecutions enter into picture. The prosecution tries to prove a case against the accused, right? And then we have the jail authorities. Jail authorities have various functions. As you know that one of the theory that we follow in sentencing is that of the reformation theory, right? So we strongly believe that we should reform an individual. In that, jail authorities hold a huge responsibility, right? If you know about this particular case that we have been discussing in classes also, right? Bilkis Bano case. There we have seen that how there is a remission committee in jail, which after going through the conduct of that particular accused can release him earlier, right? So all of those convict in the Bilkis Bano case were actually released after 14 years of jail, although they were punished for life imprisonment. Why is this? Because the jail authority in this regard have decided that the conduct was good, right? So these are the 4 functionaries. Right now, through this present session, right, we are going to learn something which is going to be useful for your CLAT examination, obviously. Now, if you go to the syllabus portion, we have been discussing this in all of our classes, that if you go to the syllabus portion, we get to see that if there is something in news, legal contemporary issues, the high chances that they would appear as passage. That means since this is one of the biggest change in law, right, we can expect a passage from here. Now, it would not be humanly possible for me to cover all the related aspects of BNSS, correct, right? And there may be some articles, some judgments that may come in future, say in October or say in September, a judgment rolls out which decides something about BNSS, right? I would definitely not able to cover all of them. Now, in this particular class, I will be teaching you certain concepts and I will be telling you what kind of articles can you expect, right? Now, if I come here, right, this is a passage that we are going to do. But before we do that, I want you guys to understand what is important under this particular law, right? The most important issue right now with regards to BNSS is its applicability. although it has been made applicable from 1st of July 2024. But what about an FIR which was filed in the month of June? To that, will it be applicable? Because FIR is lodged. The investigation process has started in July. So should this process be applicable, or should the older law, that is CRPC, be applicable? Right? Or we have also very essential, very fundamental right. Right? If you come to Article 20 of the Constitution, it talks about ex post facto laws, right? And this is something that we have been doing also in classes, right? What is ex post facto law? Can someone tell me using the comment box? We have been doing this, right? What are ex post facto laws? Retrospective laws. Someone has answered using a buffering emoji. That means the mind is buffering. They will answer it. Yeah. Retrospective laws, ex post facto laws are legal provisions that make criminal conduct retrospectively punishable. Right? Good. Right? So in this regard, we have seen certain judgments, and the passage that we are going to do today is also about that. Right? The court are essentially answering, can this law be made applicable retrospectively? Right? To this, there has been a lot of discussion. If we read the bare provision, the words of Article 23, which talks about ex post facto laws, it says that no one can be punished for an offense which was not defined at the time when they did it, or can be subject to a greater penalty than it was when they did the crime. So if I did a crime, 10 years of jail is the punishment. The law cannot impose a higher penalty to that on a future day. They cannot bring a change saying that although when you did the crime, it was 10 years of jail, now I am making it 15 years. That would be what? That would affect the accused in a negative way. Right? So Article 20 in each of the ex post facto law is very clear. It says that if you're bringing any retrospective effect, the one thing that you have to test here is whether it is affecting the accused or not. Right? Is it affecting the accused or not? Right? And essential on that itself, we get to know that whether these laws can be made retrospectively applicable or not. For example, earlier I was supposed to be tried by a court of judicial magistrate. Now the amendment brought says that I can be also tried, or I will be only tried by the session court, which is a court higher than the magistrate court. Now, can this be made applicable? Do you think it affects the right of the accused? In this particular case, if instead of being tried by a magistrate, I am being tried by a session court, do you think my rights and liability will get affected? All of you, can you answer that? Sanjana says yes. What about others? Do you think rights and liability gets affected? Whether he be tried, the accused be tried by the magistrate court or a court of session, that do you think it will affect his rights and liability? He can still present his case. He has all those rights which he has otherwise before a judicial magistrate. The same rights are there before the session court as well. So that particular thing is not affecting the rights of the accused. In that case, you can make those laws applicable retrospectively. Right? Now think of this particular thing. Now, earlier, for a particular offense, say, let's take a random offense, say 1. There is a section 1 of some criminal offense which says that when you do that particular crime, you will not be, or you will be given bail within 10 days. Now CRPC has been changed, and now the new law says, suppose the new law says that the bail will be given only after day 12. In that case, is the accused's rights getting violated or changed, getting affected? Can someone answer me? If I change the law and say that instead of 10 days, you have to wait for 12 days to get a bail, is it affecting negatively the accused, or is it positively affecting the accused? Can someone answer me? Yes, sir. Yes, sir. Yes, sir. Correct, right? Exactly. There the rights are getting affected. Now, in that case, the court would say that since the rights and liabilities of the accused is getting affected negatively, we would not impose such law retrospectively because the fundamental right, one of the fundamental right against ex post facto laws protect us. So in that case, it cannot be made applicable. So this is something that has come out in recent judgments, right? This is something that we're going to read also, right? Now, similarly, in future, you would see many judgments coming in because there has been a lot of confusion about the applicability of this particular law. So you have to search for those articles which are trying to answer whether or not it affects the accused in negative or a positive way, right? And this will tell you whether you can apply this law to a date prior to 1st of July or to cases only after 1st of July, right? So one thing we have learned, it entirely depends whether it is negatively affecting the accused or not, right? Apart from that, in this particular thing, we are going to learn about few of the concepts or few of the changes that has happened in law after the BNSS has come into picture, right? Should we get into the passage? All of you are ready for this? I want you guys to understand the passage thoroughly because then you have to answer me the questions. All of you, give a thumbs up and say that you're ready for the passage. Then we'll start with the passage. Right, so let's get started then. This is the passage that we are going to do, not this. That means it's part of the passage. We are going to read the entire passage. It's almost like 450 words. Then I want you guys to answer a factual scenario based question back to back. Right, now if you read the article, it says that the Bharatiya Nagrik Suraksha Sanhita 2023, that is BNSS, scheduled for enforcement from 1st of July 2024, adopts a citizen-centric approach, balancing the rights of both the victims and the accused, while respecting human right principles, right? This is a very basic introduction that the author has given. This new code replaces the existing Code of Criminal Procedure 1973, aiming to establish a justice system with greater efficiency to tackle changes such as complex procedures, case pendency, low conviction rates, lack of technology adoption, and delayed justice delivery. Right? So these are the things that this new law is trying to remedy. The older law was not able to incorporate or accommodate the advancement in technology. It wasn't able to provide a greater conviction rate, or it wasn't able to deal with cases on a large scale. So these procedural changes have been brought so as to make sure that these things are provided. Now let's get to the substantive portion and understand each of the changes, right? I have quoted here a few sections so that you can understand through this example how does the change in law actually works, right? So if we come here, one significant change. So we're talking about changes from here, right? One significant change is found in section 15, right? Which authorizes the state government to appoint any police officer, right, not below the rank of superintendent of police or equivalent, as special executive magistrate in addition to an executive magistrate, enhancing administrative efficiency, right? So you must not be aware of what was the older law. Let me put forth the older law. The older law used to allow, obviously, executive magistrate, IS officer. Apart from that, if you see anyone who is equivalent to or above the rank of superintendent of police in any department, he can be given the powers of an executive magistrate for any amount of time that the state government shall decide, right? State government, you have to remember this. Police function comes under state. Judicial functions also come under state. Respective states have to deal with it, right? Although right now the central government has passed this BNSS, the state governments are free, or the state legislative assembly, to be more precise, are free to make any further amendment which is suitable for their state. And you would get to see this, right? If you open the older CRPC law, right, you would see that after every section you will get to see if any state has changed that particular law, right? Almost all sections are changed according to what suits the state, right? So this is also something that you can follow. If you see any state legislature making any changes in BNSS, right, to be applicable in their respective state, please read about that as well, right? So if a state legislative assembly is specifically changing something, that means they're changing a law that would not be suitable for their state. Now try to understand the reason there and try to also understand whether it's affecting the accused or not. The same principle applies. Right? Now, apart from that, section 23 increases the fine imposing power of the magistrates. Now, what does this particular amendment do? Section 23 changes the power of a magistrate, a judicial magistrate, right? Raising the limit for judicial magistrate first class, JMFC, right? Judicial magistrate first class, his power has been increased from 10,000 to 50,000, and that of judicial magistrate second class has been increased from 5,000 to 10,000 rupees. Right? Take note of all these things, minor details. We'll be dealing with these concepts and everything while doing the questions. Right? So you're clear, right? First class power. Earlier, a judicial magistrate first class had a power to impose a fine up to 10,000 rupees only. But now he can impose a fine up to 50,000. Similarly, 5,000 was the power of judicial magistrate second class, which has been increased now to 10,000 rupees, right? We'll see how in factual scenario these things are going to affect an accused, right? Then if we come to the second portion of that same passage, now here, additionally, magistrates are now empowered to impose community service as one of the punishment, right? But who has this power? Can a session court impose community service as one of the punishment? All of you? If the word used is, no, right? So that's something which is there. So only magistrate can impose what? Community service as one of the punishment. Section 35 subclause 7 protects aged and infirm individuals from arrest for offences punishable by less than 3 years without prior permission from senior officer. I think this is plain enough. If someone has committed an offence which is punishable with imprisonment of less than 3 years and that accused is aged or infirm, right? See, although the word is and, how am I reading it? Please stress on this. Aged and infirm is actually two category of people. Someone can be aged and infirm. Someone can be just aged, right? Now, what is aged? Now, if you go and look into certain of legislation, there are social security or social welfare legislation. If you see senior citizen, pension to senior citizen act is there. That defines as to who will be called an aged person, right? Infirm person, you can find there is something known as disability act. There is mental health act. All these act defines who are infirm. So if you are either aged or infirm, in that case, if you have done an offense which is punishable with less than 3 years of punishment, in that case, you would require a prior permission from a senior officer in order to execute the arrest. Right? Now, let me put a question. Let me see who answers this. Now, what if the arrest is done by the senior officer himself? What would that mean? He still needs permission, or can he do it? Because he is himself a senior officer, no? What do you think? Still, suppose an IG is there. He's already a senior officer. Now, is IG, Inspector General of Police, is he required to take permission from anyone who is above them? Right? Can he or he cannot? Can he arrest without permission or not? If the arrest is being made by the senior officer himself, in that case, do he need to consult any of the other senior officer or not? Or can he do it himself? What do you think? What would be the correct interpretation? All of you. Depends is a good answer, although, but you can't answer. Yeah, yes, no, can. Right. The answer is he can. Right? You're saying that you have to take permission of a senior officer. When you yourself are the senior officer, that means somewhere you have the authority to do it. Right? When an officer who is not a senior officer, right? Someone who is below, who is not categorized in the senior officer, why are you telling him to take the permission? Because he doesn't have the authority. So you have to get a consent from an appropriate authority, right? Now in this case, because he is himself the senior officer, he has the authority to do it. Right? Anyhow, let's move forward. Section 63 introduces the use of technology for issuing summonses. You know what a summons? Summons is when the court is calling someone, a person, or it can be a document to be presented before the court because it's relevant for that particular case. So when they're being called, that's called summons, right? Now electronically, it's allowed with authenticated by court's seal or a digital signature, right? Thus improving efficiency and reducing delays, right? This is one procedural change. Remember in the introduction, we read about how this particular BNSS is trying or acing to include technology so as to ease the business of delivery justice system, right? Sorry, justice delivery system. Now, section 66, that comes here. Section 66 allows summonses to be served on any adult family member residing with the summoned person, promoting gender neutrality by replacing the previous requirement of serving only male family members, right? Male family members. Now, in that case, can I ask a question here? Let me see who answers this. If I am a police officer, I have a summon, or I have a summon, valid summon. I go to that person's house. I see that he's not there. And I get to know that he's not living here for a long time now. So according to older law, right? According to older law, I could have given it to only male family members, right? Now, you have to answer this to me. Now, under the present law, can I give that particular piece of document, summons, to the kid of that particular person? Suppose that person to whom the summon was being served is the father. His son is present at the home. Can I give it to him according to the new law? All of you? No. Why? Or, okay, let me see. I want more answers. Yes or no? Then we'll discuss about this. No, sir, you can't. Why? Why can I get an answer as to why? Why is it that you're not allowing? Under the new law, it says that anyone, right? That's what gender neutrality means. So uski beti hai, beta ho, son or daughter, he should be allowed to take, no? What is that? Correct. Because the word used is adult. Right? Good. So what is the question I asked? He's the son of that particular person. If he's the son of that particular person, does it mean that he is minor? Now I am son of my father, right? Am I adult or not? All of you? Can I take a summon that has been issued in the name of my father? Yes. So in this case, the statement that I have given you, what should be the answer then? We don't know. Yes, sir. Right. Okay, right. So in my case, it can be. So it entirely depends whether he's adult or not. A mere statement that I am a son doesn't imply that I am adult or not. So we need more detail as to figure out whether that person can be given this particular piece of summon or not. Right? So let's move on. Now, other notable changes in the BNSS include section 84, which expands the criteria for declaring a person proclaimed offender to include all offences punishable with imprisonment of 10 years or more, life imprisonment or death. Right? Now, I want you guys to again answer a question here. Right? Now, this particular provision, do you think this affects the rights of the accused? Rights of the accused? Say that the older law said that anyone who has committed an offense which is punishable with 7 years or higher, or death penalty or life imprisonment, they can be declared as proclaimed offender. Right? Now, under this new law, it is 10 years or more. Earlier, it was 7 years or more. Is it affecting the accused? All of you? Earlier, according to the older law, I would have been a proclaimed offender if I have done something, an offense which is punishable with more than 7 years of punishment, right? Now they have made it 10. Is it affecting me negatively? No. Rather, if I have done something which bears 9 years of punishment, in that case, according to older law, I could have been declared proclaimed offender. But now, am I getting benefited? All of you? Am I getting benefited here? Yes. So if I'm getting benefited in that case, it's positively affecting me. So such laws can be made applicable retrospectively. Right now, section 145 allows maintenance proceedings to be initiated at a place where either the dependent father or mother of the person resides, offering more flexibility and protection for dependents. So under one of the important provision, this is maybe this is something that you should take note of. CRPC is the law which provides for maintenance. Right, we have been reading maintenance a lot, right? It's not only husband and wife, the parents can also claim maintenance from their son or daughter if they have if they have been enriched by the parents. Now, in any case, all the maintenance, if you see maintenance, that the provision for maintenance was available under CRPC earlier, and now it's available under BNSS. With regards to that, it says that if the person who is claiming the maintenance, right, if it's the father or mother, in that case, what is there? It can be initiated at a place where either of the dependent father or mother are residing. So you don't need to travel to the place where the other person resides and file a case there, right? The mother or father, either of them, the place where they reside, they can file a case there itself, right? So that provides flexibility to old people, right? That is mother and father in this case. Then, right, let's quickly do this. Now, section 173 introduces the filing of zero FIR. We have learned about zero FIR. If you move to a police station which is not competent, right, or it doesn't have the jurisdiction to file an FIR, in that case, the police officer shall record a zero FIR and transfer it to a police station which has jurisdiction over that particular case. The same thing has been reflected here under 173, and also it talks about EFIR. Now, the signature of the informant must be obtained within 3 days, streamlining the process and ensuring timely action. Section 179(1) protects aged and infirm witnesses that was accused. Remember, aged and infirm accused who have done an offense which is punishable with less than 3 years of imprisonment. If they have to be arrested, you have to take permission of a senior officer, right? Have done with the situation. So it says that similarly, if a witness is aged or infirm, then it says that you cannot force them, right? If you read protect aged and infirm witnesses by not requiring them to attend court at a place other than where they resides. So if there is a witness who is aged or infirm, you have to call him to a court which is located in the place where he resides. You cannot call him to other place. Now, there is proper compensation scheme for witnesses. So if I'm traveling to some other faraway place to be a witness, usually the court gives me, or the parties give me, the appropriate cost which I have incurred in traveling earlier. So you could have, the court can force you to come to any other place provided it provides you with the cost that you incurred while traveling to that particular place. But the new law says that if you are aged or infirmed, irrespective of whether the court will or the parties will give you cost or not, you have to, the court cannot force you to travel to some other place. The only court where you can be called to be witness is the court which is located at the place where this aged infirmed witness resides. Right? Section 184 mandates that the report of a rape victim's medical examination be forwarded to the investigating officer within 7 days, who must then forward it to the magistrate, ensuring timely documentation and justice. Finally, section 398 mandates the preparation and notification of a witness protection scheme. Right? What does this particular section says? It says that it mandates, so it's a compulsory duty that has been imposed. What is that? To create a witness protection scheme by every state government. So every state government has to make their own witness protection scheme. How are they protecting witness? How are they facilitating witness so that he's not getting affected by outside factors, right? Usually people are not willing to be witnesses in the case. So to protect them, right, to provide them with that surety, with that confidence, the state governments have to do what? They have been mandated to make witness protection schemes, right? Emphasizing the protection of witness as a critical aspect of justice system, right? Now, good. So this is the verdict that I was talking about, right? A Supreme Court Constitution bench recently reiterated that any change in procedure, right? This was something that I was talking about procedure after an offence is committed would not be unconstitutional on the ground of the bar on the retrospective application of ex post facto laws contained in Article 21 of the Constitution, since procedural matters were not covered by the said clause but only offences and its punishment. So unless there is a section which creates or which kind of affects the rights of that person, till that point it will be treated as merely a procedural change, and such changes can be made retrospectively applicable. Right? Okay, let's now quickly get into the questions. We'll take a minute here. Let me see all of you if all of you are ready for the questions or not. All of you, are you ready for the questions? Three. I am going to count how many yeses I am going to get. How many yes I am going to get? 1, 2, 3, 4, 5, 6, 7, 8, 9. Sir, a doubt. 10. Okay, let's quickly take a doubt as well. You can post your doubt. Meanwhile, other people. Right. So we are going to get into the question. I will definitely discuss the answer and I will tell you how to evaluate the question and answer the question. But I want you guys to answer it. So don't see, obviously you have to be fast in your examination, but here I want you guys to stay back, think for a while, compare it to the things that we have learned from the passage, and then take the correct answer or choose the correct answer, right? So we are going to get into the questions now. Right, here's the first question. It says that Mr. X is charged with committing fraud on May 16, 2024. Similarly, Mr. Y committed the same offense on which date? July 16, 2024. According to the changed law. Now, right, the offense of fraud carries a minimum of 7,000 rupees as punishment. Right? So what is the punishment given for this particular offense that both of them have done? Both of them have done the same offense that has a punishment that that bears a punishment of 7,000 as fine. And as a general rule, you also know this, that cases must be brought before the court of the lowest competency. Right? So if there are 3 courts in seniority, court number 1 is above court number 2 and 3. Right? If all 3 of them can deal that particular case, you have to go to the court of the lowest competency. Right? In terms of hierarchy, you will go to the court of the lowest competency. Now, go through this particular question and let me see who answers this. Oof, I see very different answers from all of you. Right. Try to understand this factual scenario is saying that one offense is done on 16th of July, right, by a person called X, and then Y has committed the same offense on July 16th. Now, if today I want to file a case, right, in which court, being a police officer who has investigated this case, in which court would I present this particular charge sheet? That's the question. Right, so the first thing, there is a date in the question and there is a date in the passage. The same rule do it in the class. So if there are 2 dates, that means date is critical here. Now, is the date relevant or not depends on the fact whether this can be made retrospectively applicable or not. What do you think? The change in power, right, the magistrate's power now, do you think that it affects the rights and liabilities of the accused? We have answered this. Change of power of the magistrate, does it have the rights and liabilities? No, all of the rights and liabilities are there, right? Now, if the rights are not getting affected, that means it doesn't matter whether you have done it before 1st of July or after 1st of July. The law will be applicable to you in a similar way, right? That means here the law should be made applicable to X as well as Y. This particular new law can be extended to the person who did the offense before this particular law was brought. So both of them will be subjected to the new law. Now, according to the new law, what does it say? If 7,000 is the fine amount, which court can deal with it? Can first class court deal with it? Yes. Can second class court deal with it? Judicial magistrate second class? Yes. Both of them can deal with it. If both of them can deal with it, because 10,000 and 50,000, that is 7,000 is less than both 10,000 and 50,000. In that case, right? In that case, the court having the court with, you will move to a court which is, look here, lowest competency. Accordingly, which court will, in terms of competency, which will be lower? First class court or second class court? All of you. Second, right? So what should be the answer then? It should be both of them will be tried by judicial magistrate second class, right? You can quickly take a screenshot of this explanation, right? Quickly take a screenshot of this particular explanation. The same thing that I have told you just now, right? In case. Good. D. I'm very happy. Good, right? Now, ready for the second question, all of you? Right, so let's get into the second question. Now I want you guys to answer this. Yes, look at this. This is a statement based question. I have told you that whenever there are statement based questions, statement individually, you have to test whether they are true or false. That's your only duty here. Don't look for relevance. Read the passage. In the backdrop of passage, is it true individually or not? Mark true and false for all of the three statements and then tell me what should be the correct answer here. You can post your doubt in the comment box, right? Keep it in double quotes so that I can, it is visible, right? Separately. Put it in double quotes. A lot of people are answering it B and C, right? It's very excluding, right? So a set of people are saying it's only 2 and the other people are saying 2 is the only statement which is false, right? Now, let's look at the question here. Mr. Kidhar Prasad was arrested by the police for the offense of criminal breach of trust, punishable by a minimum of 3 years and up to 7 years of imprisonment. Right? Now we are looking at the aged and infirm portion of the passage, right? If you come to the aged and infirm, it says that if you are either aged or infirmed, right, and being made punishable with an offense which has a punishment of less than 3 years, right? Now here it's minimum of 3 years. Now let's take that 3 years case now. Suppose that he falls under that category, 3 years. Can he be arrested, a person who is aged or infirmed? Can he be arrested? All of you, can he be arrested? Satya says yes. Satvika Reddy says no. What about others? Can he be arrested or no? Yes or no? If you are a police officer, someone comes to you, he says that I'm aged and infirmed. Can you arrest that person if he has done an offense which is punishable with? Now, right. So if you come here, right, it says that he can be arrested provided he takes permission from a senior officer. Now answer me. Can he be arrested if he gets a permission from a senior officer? Aged and informed person. If he gets a permission from a senior officer, can he be arrested? So they're not saying that with or without permission. They're saying, can they? Yes, they can if they get prior permission from the senior officer, right? If you go with that logic, if you go with that logic, what should be the answer then? All of you? Statement. Mr. Kidar Prasad cannot be arrested by the police officer if he's aged or infirm. It's wrong. He can be if the prior permission or prior sanction is taken from the senior officer. Then the second statement, Kidar Prasad can be arrested by the police if he's aged but not infirm. It's true. If he's aged but not infirm, he will fall under that category. But if he gets a prior permission, he can be. Right? So this is individually true. This is false. And if you come to the third statement, that's also false. So the answer should be B. Right? Let's quickly move to the next question. Take a screenshot of this. Now, the third question is easy. At least in this question, I want you guys to answer correctly. Okay? Right. So we'll quickly come to the question. Take a minute, do it, and let me see if you answer it correctly or not. Right. What does the question say here? It says under section, again, statement based question. Look at the statements individually and mark true or false. That's how you proceed, right? Under section 66 of the BNSS 2023, which scenario illustrates the provision for serving proper summons? We have seen that now the law has been made gender neutral. It can be given to any adult member, right? Any adult member of that particular family where he resides. So obviously, if you go with that, all of them are adult and they reside with the person to whom the summon is issued. In all 1, 2, 3, the statement is true because they're adult and they reside. Whereas in the third case, it would not be gone. Maybe there are some other provisions which allow you to send a summons to other places, but we are talking about the residential building of that residential place of that particular person. In that case, the fourth statement is false and the answer should be C, right? 1, 2, 3 are the only true statements, right? Okay, let's do the fourth question here quickly. Take a screenshot of this if you need the explanation, right? Anyhow, make this as a PDF. It's already there in a PDF format. I will make sure that it is given to you in your respective WhatsApp groups, right? So that you can access it, right? Now the fourth question, let's do this together. How does section 398 of BNSS address the protection of witness in a hypothetical scenario? Singh. Now, does this act directly protects Mr. Singh? All of you. What does this particular act talk about? Witness protection. Does it say, this act itself says that witness has to be protected in this case, that case, or who has been given this discretion, power, right? Or rather an obligation has been put on which entity to make laws, to make policies to protect witness? Does this act itself protect the witnesses in different scenarios? No, it doesn't talk about all those things, right? What does it say? Who has been imposed with this duty? It mandates that the state government shall, right? Correct. Accordingly, what should be the answer? All of you, quickly. D, yeah. State, correct. Madhunika, D. Right. This was an easy one, right? This was an easy one. Now, we'll move to the next question, the last question of today's class. Even this is a simple question. So I want you guys to quickly answer this, all of you. Right. I think you got it. You got it. All of you. Most of you have got it. It's B, right? Obviously, because the law says that you cannot call a person who is aged or infirm as a witness in any court apart from the court which is located in the place where this particular person resides. So Rani Indumati, she lives in Dholakpur, so she can be called to be witness in any case only in courts located in Dholakpur, right? So if we go with that, option B should be the answer, right? Yeah, there we have option B is the answer. With that, we have come to end of this particular session, right? I was searching for some doubts here. If you have any doubts, please post it, all of you. Otherwise, we will end the now here. Sir, can seniority of police officer be interpreted? Yes. Although it's not given in the passage, the seniority of police officer is decided. The seniority of the courts are also decided as to who will be above whom, right? If you talk about the basic functionaries, as I was telling you, that police is one of the functionary. In that chapter, you will find that an investigation can be only be done by a person who is not below the rank of station house officer, and there is a proper defined hierarchy. So if this word senior comes into picture, right, that is given the provision. Also, it's not given the passage itself, right? It is mentioned in the BNSS. So seniority can be interpreted from this particular thing, but I have to look into the relevant portion. But the law does describe about BNSS, the seniority of police officer. So who is the senior police officer whose permission is required is definitely defined. The seniority thing is defined. Right. Anything else? ये सब कल के एग्जाम नहीं आएगा. So ये कोई भी एग्जाम में नहीं आएगा. If Abhyaas is conducting, the only place this particular concept can come is the CLAT 2025 paper that you're going to have on 1st of December. And we are preparing you for that. We are not preparing you for the immediate mocks, right? But I know that if you have understood this portion, this will help you somewhere else. So in any other mock that you write, these concepts, the way I have been interpreting here, when this particular date is given, or when it's a statement based question, how do you approach? If these approaches, if you understand, no, that will be useful. Right, sir, can you explain? We can go to the third question here. Right. Right, the third question, you have seen the relevant provision. It says that the summons can be issued to that particular person at his residence. If at residence he is not there, then you can hand over that summon to any other member who lives there. Right, it can be your family member, the person who lives with you in that same house, he can be handed over that summon. In that case, it would be said that the summon has been properly served. Right, so there is something known as serving of summon. It will be completed only when you hand over the summon. Right, if you have just a summon as a document, doesn't mean that it has been served. To call this particular thing as a proper summons, serving of summons, you have to make sure that it is either given to that particular person or it is given to any of the family member. Now, earlier the law was that it could be handed over only to a male adult member of that family, but now you can hand it over to any other person. So if you go by that, in all of these three conditions, there is an adult member who is living in the same house, same family member, they can be given this particular summons, and that will be a proper service of summon. Whereas the last one, it's talking about the place of work, which is something this particular provision, at least the provision that we have read from the passage, doesn't talk about. So for that reason, we cannot say whether it's valid or not. Maybe it's valid, but it's not definitely something that we can construe after reading the passage. For that reason, the last one is wrong. Right, all of you, is that clear? Sir, can we see BNSS in CLAT 2025? Yes, that's the reason that we are conducting this session. But which aspect of BNSS will be tested? That cannot be assured. As I was telling you that maybe in October or in coming time, we will get to see landmark judgments on this particular law. In that case, that particular concept will come in the exam. So I cannot assure you that which concept will come, but there are high chances, because this is a very important move from the government, that they have changed the criminal laws. Criminal laws, they're very old. If you look at the IPC and everything, IPC was made in 1860. So this change in law is definitely a very critical in terms of what it has done. It's very important. So if something is important, something stays in news, I have been telling you, there's a high chances that it may come. So it may. When will be the next class? The next class will be most probably on next Saturday, same time, 2:30, if I'm available. Otherwise, next to next Saturday, whatever it would be on Saturday, 2:30. So if you see a live being created saying that 2:30 on Saturday, join in. Otherwise, anyhow, you will be informed in your WhatsApp group, right? So with that, we come to end. I hope that you enjoyed this, or is it just my hope only? How was that? You guys enjoyed this session? We'll bring more complicated laws. This was the first session, so I made sure that it is somewhat easy. We'll bring complex laws and difficult questions so that we can I can train you for the worst, right? If it ever comes, right? With that, we come to an end. All of you, thank you so much for joining. It was really wonderful. I'm very happy with this session, right? Let's meet next week. Thank you so much.